Good morning and welcome to the South Carolina Public Service Commission. Today is Tuesday, July 22nd, 2025 at approximately 10 a.m. We are here today concerning docket number 2025-15E, Dominion Energy South Carolina Incorporated's 2025 avoided cost proceeding. All commissioners are present in the hearing room. Ms. Wester-Hill, if you would please explain this docket so we can proceed.
Thank you, Mr. Chairman and Commissioners. The hearing before you today is in docket number 2025-15E, as the chairman just mentioned. The docket concerns the review and approval of the application filed by Dominion Energy South Carolina Incorporated on March 3rd, 2025, related to the avoided costs proceedings. The company's avoided cost application seeks approval and in some instances reapproval of previously commission approved matters concerning the company's avoided cost methodologies and corresponding tariffs. Reapproval of its unchanged and previously approved standard forms, which include the standard offer, form contract power purchase agreement, and notice of commitment forms, and approval of all other terms and conditions pursuant to South Carolina Code annotated section 58-41-20 subsection A. The hearing was scheduled and noticed by the clerk's office to begin today at 10 a.m. and is subject to continue through the remainder of the week if necessary. Mr. Chairman, upon inquiry of all participating counsel of record, counsel for the parties of record are present and available upon your call for appearances. There is one preliminary matter requested by the Office of Regulatory Staff and the company concerning a recently executed stipulation. Otherwise, Mr. Chairman, the docket is ready to proceed at your call.
Thank you very much. Would the parties please introduce themselves, beginning with Dominion?
Good morning, Mr. Chairman and members of the Commission. My name is Chad Burgess, and with me is Elizabeth Hutton. She and I are in-house corporate counsel for Dominion Energy South Carolina, and also with us is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel. It's a pleasure to appear before you today, and we appreciate the opportunity to be able to present the company's case today.
Thank you. It's a pleasure to have you here. Mr. Witt?
Chair Powers, members of the Commission, I'm Richard Witt from the Witt Law Firm, and SECEBA's general counsel planned to attend today, but he had a family commitment that came up this morning, so he's not able to participate, but thank you.
So Mr. Burns will not be participating.
All right.
Okay. All right. Office of Regulatory Staff.
Good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. My name is Chad Torrey. I'm joined today by Claire Benge, and we're here for ORS. Thank you.
Thank you very much and welcome. All right. We got something we need to proceed with before we start.
Yes, Mr. Chair, briefly, if I may discuss the stipulation.
Sure.
Again, good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. On July 18th, 2025, ORS filed in this matter a stipulation between it and the company. On July 21st, 2025, SECEBA, the only other party in this case, filed a letter stating that although it is not a signatory, it does not oppose the agreement set forth in the stipulation. I believe the Commission will find the stipulation addresses all issues related to the company's 2025 avoided cost filing that the Commission is required to decide under the avoided cost statute, South Carolina Code annotated section 58-41-20. In particular, the stipulation addresses the company's standard offer contract, form purchase power agreement, and notice of commitment to sell form. Stipulation also addresses the company's avoided energy cost, the company's avoided capacity cost, and the company's variable integration charge. Mr. Chair, if I may, I would ask that the stipulation that was filed be marked for identification and entered into the record as the first hearing exhibit.
The stipulation agreement as filed will be entered into marked for identification and placed in the record as exhibit number 1.
Thank you, Mr. Chair. Thank you.
While you're there, could I ask one thing? Since it's a stipulation rather than agreement, are there any issues that are now at it? Anything at issue now, or it's all covers all matters?
The terms of this stipulation are resolve all issues that the commission needs to decide in this avoided cost case.
All right. And Mr. Witt, you have no objection to the stipulation being put in the record?
No objection.
Okay, thank you very much. And obviously, the company does not. All right, thank you. All right. Anything else before we start?
That's all, Mr. Chair. Thank you.
Dominion, floor is yours.
Thank you, Chair Powers. The company will call its first panel of Eric Bell, Jim Neely, and Chris Gore.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. I bet I have one that has it written on both sides somewhere. No?
Chair Powers, members of the commission, per the terms of the stipulation, ORS and the party and the company have agreed to stipulate testimony in the record. So I thought with the chair's indulgence, I would have each witness identify their name for the record. Then I will direct you to what is being stipulated into the record.
Certainly.
Mr. Bell, could you please state your full name for the record?
My full name is Eric H. Bell.
Okay. And Mr. Bell, can you tell the commission by whom are you employed and in what capacity?
I'm employed by Dominion Energy Services in capacity of Dominion Energy South Carolina's electric market operations manager.
Thank you. In Chair Powers, Mr. Bell pre-filed 37 pages of direct testimony on March 3rd, 2025, and we ask it be entered into the record as if given orally from the stand.
The pre-filed direct testimony, Mr. Bell, will be entered into the record as if given orally from the stand.
Thank you. Mr. Neely, could you state your full name and your employer and occupation, please?
James W. Neely, Dominion Energy Services. I'm an energy market strategic advisor.
Thank you. And Chair Powers, we have 3 pieces of testimony from Mr. Neely. First is his direct testimony consisting of 18 pages, also pre-filed on March 3rd. I ask that be entered into the record if given orally from the stand.
The pre-filed direct testimony, Mr. Neely, will be entered into the record as if given orally from the stand.
Thank you. Mr. Neely also has 12 pages of rebuttal testimony pre-filed on June 19th. I ask that be entered into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Mr. Neely will be entered into the record as if given orally from the stand.
Thank you. And then finally, Mr. Neely pre-filed 5 pages of stipulation testimony on July 21st, 2025. The company asked it be entered into the record as if given orally from the stand.
The pre-filed stipulation testimony of Mr. Neely will be entered into the record as if given orally from the stand.
Thank you. Mr. Gore, could you state your name, occupation, and employer, please?
Christopher Gore, Associate Director at Guidehouse in the Integrated Market Modeling Team.
And you're here today testifying on behalf of the company?
Yes.
Okay. Mr. Chair, Mr. Gore had 31 pages of direct testimony pre-filed on March 3rd. We ask that be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Christopher Gore will be entered into the record as if given orally from the stand.
Mr. Gore had 2 exhibits. The first was CJG1. We ask that be entered into the record. And then the company would like to note that in its pre-filed testimony, CJG2. What should have been CJG2 was inadvertently labeled CJG1 again. We have now since corrected that filing on DMS, and the only change is the little label in the top right corner. There are no substantive changes to the exhibits. So if we could have what is now CJG2, which is the VIC study, be entered into the record, and those can go in as a composite hearing exhibit.
All right. CJG1 and CJG2 will be marked for identification and placed in the record as exhibit number 2.
Thank you. And Mr. Gore also had 14 pages of rebuttal testimony pre-filed on June 19th, 2025. I ask that be entered into the record as if given orally from the stand.
The rebuttal testimony of Mr. Gore will be entered into the record as if given orally from the stand.
Thank you. That completes the introduction of the testimony and exhibits of this panel, and we now tender them to the commission. And I believe Sasiba is not planning to cross, but I'll let Mr. Witt confirm.
That's correct.
All right. Thank you. Any questions from ORS?
No questions.
Thank you very much. Commissioner questions? Commissioner Belson.
Thank you. Mr. Neely, I think most of my questions may go to you, but if we need to tag team somebody else in, we can certainly do that. I just would like to kind of go through your settlement or stipulation testimony and understand where y'all have agreed, and then what is going to be done in the future. I think there's some things that y'all are going to work on with ORS, and I'd just like to have a better understanding of those if we could. So, with regard to the contracts, those seem to be okay, and everybody's agreed that those forms are sufficient.
There was no issues with those forms.
Okay. And then tell me about the with regard to the avoided energy costs, what the agreement does.
Well, the agreement changes the time of production periods that the company put forth in my testimony. The standard offer that we proposed had 11 time of production periods. The ORS recommended we shorten that to 10, and the company adopted that change. And then with the PR1 rate, we put forth a 4 time of production periods, and the ORS recommended that be changed to 5 time of production periods, and the company adopted both of those changes.
Okay. And with regard to, and this may be more appropriate for Mr. Ming, but with regard to ORS's recommendations, those recommendations came from Mr. Ming's evaluation of the application and what Dominion was asking. Is that correct?
That is true.
Okay. And then with regard to the avoided capacity cost, what could you tell me what the stipulation does with that?
Yes, and so the ORS recommended 3 changes to the calculation of avoided capacity. One had to do with net versus gross capacity. The other one had to do with capacity in periods when we had no capacity need. And the third one had to do with using a frame combustion turbine as the proxy for the calculation versus the aeroderivative combustion turbine. So the company agreed with 2 of those 3 changes and adopted 2 of those, and ORS accepted our change, or accepted us only using 2 of those 3 components of the change to the avoided capacity. And they recommended and asked us to agree to talk about that one that we didn't accept before the next avoided cost filing, and we agreed to do that.
And that's in 2 years, correct?
Yes, that's correct.
Pursuant to the statute?
Yes.
Okay. And then with regard to the variable integration charge, or the VIC, tell me what happened there.
So I'm going to let Mr. Gore talk about what the ORS recommended and how we responded to that.
Okay, thank you.
ORS recommended that we evaluate how we use solar as a dispatchable resource in the model to provide reserves, and how we would curtail solar in the future. And so I think that was the main one was curtailing. It was all about curtailing solar. What solar looks like in the model and its ability to provide a reserve for itself, as well as evaluating the possibility of actually curtailing solar to remove reserves that would otherwise be needed to support solar on the grid during certain hours if it would save money. So those are, I think, the two main parts of those recommendations.
And those recommendations, are those modeling inputs?
Those are modeling inputs.
Okay.
And then
going forward, what's the agreement?
that's going to, I'll defer to the company on how that we're going to do that meeting before the,
Okay.
I forget what it's called.
Yeah, let me address that. That we agreed to a technical review committee before the next avoided costs, in which we would, with the parties of this hearing, work to evaluate both all the inputs, assumptions, and the modeling of the VIC. And so before we kick off the next avoided cost hearing, we'll have a meeting. If we select a Guidehouse to be the consultant to do the calculation, Guidehouse, us, our consultants, ORS, their consultants, and SCEBA and their consultants will get together and look at the modeling inputs and assumptions, and then once Guidehouse or the consultant has done the calculation, we'll have another meeting to talk about preliminary results. So all of that will take place before we submit our application to the next avoided cost hearing.
So, but let me just see where we've been, if we could. The way these cases have been going is Dominion and its consultants and its internal folks, they put forth the inputs that they think are best for Dominion system and comply with the statute, and that's what they run the model on, very simply put. Is that correct?
That's correct.
And then when we get to these proceedings, once the application's filed, the parties can conduct discovery, they consult with their consultants and challenge certain inputs once we're in the proceeding, once the application's filed. Is that correct?
That's correct.
And then it comes to this commission, and we're tasked with figuring out whose inputs are right. Would that be fair?
That's correct. That's how it's been for the last three, include this one, last four avoided cost hearings.
So what y'all are proposing with this part of the stipulation is that before the next one, y'all will do some of this and try to talk to each other before we get to the hearing stage to figure out if there can be agreement reached on some of the inputs. Is that correct?
That's correct.
Well, I applaud y'all for that. Thank you. Thank you very much, Mr. Neely, Mr. Gore. Sorry, I don't have any questions for you. Thank you, Mr. Chairman.
Thank you, Commissioner Belser. Commissioner Belser, Mr. Neely used the word proposing. Can we use the word promise? We promise to do it.
We are fully committed to doing it.
All right. Further commissioner questions? Commissioner Carolee Williams.
Thank you, Chair Powers. Good morning, everybody. My question is more of a reflects on the fact that this is my third time to be exposed to this avoided cost proceeding, and understanding a little bit better what is going on, and also thinking about it over a continuum. So my question has to do with the VIC, and that charge is $1.94 per megawatt hour, right? That's what's proposed, and that's a reduction, correct? You shook your head, and I guess I need you to confirm that, Mr. Bell. It's a reduction, and it's a reduction from what?
I believe it's 279, but I'm not the strongest one here on the panel on those numbers. So
it is $2.79 currently.
Okay, and not much else in this world is coming down in price, correct, or in value. And so my question is, what are the factors that led to that reduction?
Well, Commissioner Williams, there's a lot of factors in that because there's a lot of inputs to the models. One thing that we think is important in this one is that we're using an IRP build plan, which is an IRP case, and it is replacing inflexible dispatchable coal units with, either and I don't remember exactly which build this one is, but if it replaces with a combined cycle or a combustion turbine, it becomes more flexible and it reduces those charges. Also, any addition of batteries will reduce those charges, and then lower fuel costs will also lower. So it's a combination of factors.
Lower fuel cost related to not using dispatchable coal. Is that what you?
Well, lower fuel costs as an input to the model, which could be existing gas and coal units.
Okay. Okay. And did the cluster method change the price of the BIC at all?
Not sure what you're referring to there on the cluster, but like I said, we use the IRP build plan.
Right.
And the closer we get, we've been doing this for, I guess you and me have been doing this for 6 years now.
Right.
And over that 6 years, we've gotten closer to the coal replacements in the IRP. So that's fewer years that have those higher costs of carrying operating reserves.
Okay. And what I meant about the cluster, it's been more than 2 years since Dominion has been looking at integration in a cluster, a geographical look, as opposed to based on kind of a chronological look at who was trying to interconnect. I didn't know if that made a difference, and that's what I was trying to ask about.
Yeah, I do not think, I've not really thought about that whole lot, but
Okay.
I don't think that's impacting this
Okay.
answer.
Good to know. Thank you very much. No further questions.
Thank you, Commissioner Williams. Vice Chair Williams.
Thank you, Mr. Chair. Good morning, gentlemen. How are you all doing today?
Very
Great, thanks.
Good. My question is for Mr. Neely, and it possibly ties into Commissioner Belzer's praise regarding the willingness to come together and discuss inputs prior to coming before the commission. And I'm just curious, Mr. Neely, considering your participation in these cases since the beginning, is there anything that has changed since the first filing of an avoided cost?
Are you thinking specifically of the VIC, or are you talking about just in total?
In total, the
Yeah.
process, because if I remember correctly, maybe adversarial is a fair word to describe the initial proceedings.
There has been some proceedings that were initially adversarial. That has changed, and that hasn't changed because we did things differently, I don't think, but we've been using the same methodology to calculate both avoided energy and avoided capacity since the beginning. There have been recommendations by various groups, ORS, London Economics, some of the other interveners that have been incorporated, and perhaps that process of incorporating the recommendations has made a difference in why there is no adversarial. The hearing is not adversarial, so I think that's got to be a part of it.
And gentlemen, Mr. Bell, Mr. Gore, I don't want to leave you out, but I don't know if you have as much experience with avoided costs here at this commission as Mr. Neely does, but I welcome any comments because, I can feel the change. It's a good change, I think, but just curious as to your experience and thoughts regarding that.
My boss has a phrase that largely our process is wash, rinse, repeat. It's become very not rote, but it's a known methodology. We've been doing it over and over at a high level. But I think what the technical review committee would do would look at more details than that.
That's all I have, Mr. Chair. Thank you, gentlemen.
Thank you, Vice Chair. Commissioner Cass.
Thank you and good morning. Now, thank you and good morning.
Good morning.
I guess relative to this technical panel you'll have and the discussions that have been had so far. And thinking about and I'm not trying to pick at the scab, and if you can't go into detail on this because of the stipulation, I understand. But you're thinking about the, I guess, disagreement with ORS witness Ming, I think, relative to curtailment. You know, on the one hand, I think it was you, Mr. Neely, that pointed out that under PURPA, Dominion doesn't control that curtailment unless it's an emergency. And in Mr. Ming's rebuttal, he, I think, talked about model results inconsistent with Mr. Gore's explanation. And I've kind of gone through that a few times, and I gotta be honest, it's still kind of murky to me. So there's a part of me that would really like to kind of get a good understanding of all that. But again, I don't want to pick at the scab. Y'all have agreed to everything, and you know, this amongst other things going to be discussed in your future technical committees. But anything that you can say that might shine a little light on that for me?
You want to address that?
Yeah. So I think looking at what Mr. Ming submitted as well, referencing some study they did in Tampa on a theoretical basis, a lot of the curtailment is an expectation based on prior studies that seems like they've done, and in those studies, they restricted exports from that balancing authority from Tampa, and in our studies, we don't restrict exports. So part of the thing that I think, you know, witness Ming sees is that, there's not a whole lot of curtailment in general, and that's because we allow for solar to be exported off the system if it's overproducing to this, as long as there's enough transmission capacity. And then another aspect of it is just how the reserves are set up. We don't allow solar to actually provide reserve for solar. We don't allow it to curtail itself so that it can ramp back up in the model. And this has been discussed in prior proceedings as well. And that's just to stay consistent with how the company currently operates. And then in the future, we don't see a change to that happening. So, we don't add that to the model. And I think witness Ming's point is that, that we should, in that, because they've done that. But, it's just, I think it's a disagreement on the way that we look at futures and what is possible and what's going to be happening and how we want to make sure the study's done. And then another aspect of it too is the emergency, minimum generation events, what they are and what can be done for them. And that's when curtailment occurs in our model, is because there's too much generation, so you have to reduce it, and you can't do. And that I think some of the disagreements in our back and forth were that somehow you'd be able to just that you'd be cutting off CTs that are providing reserves as part of that, and the CTs aren't actually running; they're just sitting offline, ready to provide reserve. So I think that it's kind of one of those things where I think that this, when we talk before everything gets kicked off, I think talking will probably help ameliorate some of those issues, because I think some of it is people have pictures in their heads about how they want to model things, and it may not. And once you talk it out, you kind of understand why things are done a certain way, instead of through writing back and forth.
I noticed you look at him, Mr. Neely. Did you want to add anything to that?
Yeah, I do. The Technical Review Committee, it's not just us receiving inputs about how to set up the model. It'll also be about educating the ORS and their expert on how we operate our system. And I think it's a two-way street. So we think it will be valuable in that way, as long as all the parties are willing to listen and to process and to learn. So I think that's what we expect to see out of this Technical Review Committee.
Well, I appreciate that, gentlemen, because that's exactly what you just did for me, to listen and learn, because that was very helpful. And and at the risk of oversimplifying this and being totally wrong, I think what I heard is differences are normal in that, you know, if you're looking at a system, I think you mentioned Tampa, that maybe operate differently for various and sundry reasons, you know, where they're on the world and everything else. Each system may have nuance for a reason, and part of what you've agreed to do will be to receive and give input. Is that correct?
That's correct.
And that was very helpful. Thank you very much.
Thank you, Commissioner Caston. Commissioner Belser.
Thank you. Sorry to hit you again, Mr. Neely, but I just want to clarify one thing. When we were talking about the technical review committee earlier, I understood you, and if I misunderstood this, please correct me, that you said all the parties to this proceeding, including SCEBA and their consultants, would be able to participate in this technical review committee. Did I misunderstand that?
No, that's correct.
Okay. Now the stipulation, and this may need to go to council, says the stipulating parties, and my understanding is SCEBA is not signed on to the stipulation. They don't object to it, but they haven't signed on. Is that correct?
They haven't signed on. That's
okay,
correct.
But regardless, y'all have agreed that SCEBA can participate in the technical review committee. Is that correct?
I'm going to let my attorney answer that.
Well, I don't want to interrupt testimony or.
Commissioner Belser, we have it in writing that SCEBA will participate from a southern gentleman over here, Chad. So we have it in writing.
Okay, I just want to make sure that there wasn't a misunderstanding there. So
no, thank you.
Thank you, Mr. Neely. Thank you, Mr. Witt. Okay.
Thank you, Commissioner
Well, that
Belser.
brings up another question.
Sure.
Are there any other outside agreements that have been executed among the parties that pertain to this stipulation?
No.
Okay.
No.
Okay, thank you.
Any further commissioner questions? Hearing none, gentlemen, you may step down. Thank you very much for your hard work on this case.
You're welcome.
Thank you. The company will call its final panel of Eddie Folsom and Alan Rooks.
Gentlemen, if you would raise your right hands when you're ready. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you. Mr. Rooks, could you please state your full name, employer, and occupation for the record?
Yes, it's Alan W. Rooks. I'm employed by Dominion Energy Services as Manager of Regulation for Dominion Energy South Carolina.
Thank you. And Chair Powers, Mr. Rooks pre-filed 7 pages of corrected direct testimony on June 19th, and I ask that be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Rooks will be entered into the record as if given orally from the stand.
It was his corrected direct, Mr. Chair.
Corrected direct.
Thank you. And as part of that corrected direct testimony, Mr. Rooks had 6 exhibits, and I will list them. Corrected AWR1, corrected AWR2, AWR3, corrected AWR4, corrected AWR5, and AWR6.
The corrected exhibits of witness Rooks, AWR1, AWR2, AWR4, AWR5, and the 2 exhibits with no changes, AWR3 and 6, are now identified and marked for identification and placed in the record as exhibit number 3.
Thank you, Mr. Chair. And Mr. Folsom, could you state your full name, occupation, and employer, please?
Yes, my name is John E. Folsom Jr. I'm employed by Dominion Energy South Carolina, and my function is strategic advisor focused on power markets.
Thank you. Mr. Folsom had 7 pages of pre-filed direct, which we did on March 3rd. I ask that be entered into the record as if given orally from the stand.
The pre-filed direct testimony of John Eddie Folsom will be entered into the record as if given orally from the stand.
Mr. Folsom had 3 exhibits, JEF1 through JEF3. I ask those be entered as Exhibit 5.
The pre-filed exhibits of
Excuse me,
witness
4.
of John Eddie Folsom, identified as JEF 1 through 3, are marked for identification and will be placed in the record as Exhibit number 4.
Thank you. And the panel is now available for questioning from the commission, and if Sasiba has any.
Any questions, Sasiba?
No questions.
ORS?
No questions.
Commissioner questions? Boy, you got off light today. We have none. So obviously no redirect.
No redirect. No, sir.
All right. Thank you very much, gentlemen.
That concludes the company's case.
All right. ORS.
Thank you, Mr. Chair. ORS calls James Finley Salter to the stand.
Mr. Salter, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Salter, could you please state your name for the record?
James Finley Salter.
And by whom are you employed and in what capacity?
I'm employed by the Office of Regulatory Staff as the Deputy Director of Energy Planning and Emerging Technology.
And did you prepare or cause to be prepared direct testimony consisting of 10 pages pre-filed in this proceeding on June 5th, 2025?
Yes, I did.
Do you have any changes or corrections to your direct testimony?
No, I do not.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Mr. Chair, OS would move the direct testimony of James Finley Salter be entered into the record as if given orally from the stand.
The direct testimony of Mr. Salter will be entered into the record as if given orally from the stand.
Thank you, Mr. Chair.
Let me, I didn't mean to overlook you, Mr. Witt. You have no witnesses to present.
That's correct.
I just wanted to stay in the proper order. Thank you.
Thank you, Mr. Chair. Mr. Salter is available for questions.
All right. Any questions from the company?
No questions, Mr. Chairman.
Sasiba?
No questions.
All right. Commissioner questions? All right. You may step down. Thank you very much.
Thank you.
Mr. Chair, ORS would call Zachary Ming to the stand, and he is appearing virtually.
All right. Mr. Ming, good morning.
Good morning.
Can you hear me okay?
Yes, loud and clear.
Would you please raise your right hand? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. Your witness.
Thank you, Mr. Chair. Good morning, Mr. Ming. Could you please state your name for the record?
Yes, my name is Zachary Ming.
And by whom are you employed and in what capacity?
I'm employed by Energy and Environmental Economics, or E3. We are an energy consulting firm, and I'm a partner at that firm.
And did you prepare or cause to be prepared direct testimony consisting of 44 pages pre-filed in this proceeding on June 5th, 2025, in both confidential and public disclosure versions?
Yes, I did.
Do you have any changes or corrections to your direct testimony?
No, I do not.
If I asked you the same questions today as those posed in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Mr. Chair, I would move that the pre-filed direct testimony of Zachary Ming be entered into the record as if given orally from the stand, and ask that the confidential version of his testimony remain under seal with the commission.
The pre-filed direct testimony of Mr. Ming will be entered into the record as if given orally from the stand. The confidential version of testimony or exhibit shall remain confidential unless or until the commission rules that such information is not entitled to protection from public disclosure, or if the requesting party agrees that such information is no longer confidential or proprietary.
Thank you, Mr. Chair. Mr. Ming, did you also prepare or cause to be prepared 2 exhibits marked as Exhibit ZM1 through Exhibit ZM2 that accompanied your direct testimony?
Yes.
Do you have any changes or corrections to any of your exhibits?
No, I do not.
Mr. Chair, ORS would move that Exhibit ZM1 through Exhibit ZM2 be entered into the record as the next composite hearing exhibit.
The pre-filed exhibits of witness Ming identified as ZM1 and ZM2 are marked for identification and placed in the record as exhibit number 5.
And Mr. Ming, did you also prepare or cause to be prepared surrebuttal testimony consisting of 14 pages pre-filed in this proceeding on July 3rd, 2025?
Yes, I did.
And do you have any changes or corrections to your surrebuttal testimony?
I do not.
And if I asked you the same questions today as those posed in your pre-filed surrebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chair, I'd move that the pre-filed surrebuttal testimony of Zachary Ming be entered into the record as if given orally from the stand.
The pre-filed surrebuttal testimony of Zachary Ming will be entered into the record as if given orally from the stand.
Thank you, Mr. Chair. Mr. Ming is available for questions.
Thank you very much. Any questions from the company?
No questions.
Questions? Commissioner questions? Commissioner Williams.
Thank you, Chair Powers. Good morning, Mr. Ming.
Good morning.
Were you listening earlier when I was having a conversation with Mr. Neely and Mr. Bell about the ways the VIC charge has changed over time?
Yes, I was.
Do you have anything to add on that in terms of what you're seeing from other utilities and balancing areas? And is that a trend? Is it one that might continue?
Yes, it's a great question. So I would say in general, there are 2 trends that are changing VICs, or there's different names for that, but we'll just say VICs across the country. One that the company correctly identified is that as more flexible generation, like natural gas and batteries, are added to electricity systems, that flexibility decreases the cost of integrating renewables, and so that pushes VICs down. The other countervailing trend is that as renewable penetrations grow, that can put upward pressure on VICs. And so I think in general, the additional flexible generation that's being added to systems outweighs the impact of renewable growth. And so generally, we do see this trend right now where VIC charges are flat to declining. I think that's present in most jurisdictions, and Dominion is well in line in that regard.
Thank you very much. I think I have no further questions, but thank you very much.
Thank you.
Thank you, Commissioner Williams. Any further commissioner questions?
Chair Powers.
Commissioner Caston.
Good morning, Mr. Ming.
Good morning, Commissioner.
Similarly, did you hear the exchange between Mr. Gore, Mr. Neely, and myself earlier relative to curtailment discussions?
Yes, I did.
Good. Anything you'd like to add or comment on relative to, I guess, the questions and response?
Yes. So I think I'm really looking forward to the technical review committee when that kicks off before the next avoided cost proceeding in 2 years. I think I remember you saying that you had some confusion about some of what was written in the testimony and the back and forth. I will say that I share some of that confusion, and I think that's why this technical review committee is going to be so valuable, because it's going to be able to allow us to dig into some of the details that's really difficult and sometimes just not practical in a hearing type of situation with discovery and written back and forth. So that's one thing I wanted to say. I think, as my testimony states, I think I do see several things differently, have a different perspective than the company on the way in which both the way in which the company does and can operate. I think that's kind of one area of disagreement that we can unpack in the next proceeding. I think, and specifically what I mean by that is the way in which solar is curtailable. I think there's some unclear distinctions in terms of, clearly the company can curtail solar because they have curtailment in their modeling, and the question is what conditions can lead to curtailment, and what needs to happen if the company does curtail. I think there's some areas that could be cleared up there. But aside from the way the company operates, I think there's yet another question of the way in which the company models how they operate. And I think there are some open questions there that I've raised in my testimony, including when the company does have to procure additional reserves, what's the cost of those reserves? Is it based on a oil-fired CT or gas-fired CT? That's one issue. And then, just kind of unpacking some of the more detailed modeling questions around how they model their operations. So those might be a couple thoughts I have based on the earlier exchange, but happy to answer any additional questions if there's anything we'd like to unpack further.
No, I appreciate your candor, and I'm glad to hear that you support the idea of their technical committee and look forward to participating. And I guess relative to, the comment and the response from them on every utility operates a certain way, not saying one's better than the other, but they have their own nuance. And some of that can be regional, some of it can be philosophical. Got a host of reasons, but do you agree with that?
Well, of course, I absolutely agree that every utility is different, and when you're looking at how a utility operates, and you need to look at the specific issues that are relevant for that utility. I think where I disagree, or where I think there's more to unpack, is on the ability to use solar curtailment to reduce the cost of integrating solar. I think that concept, as that strategy as a concept, is something that every utility that I'm aware of that is trying to integrate higher penetrations of renewables, whether it's solar or wind, every utility that's trying to do that is learning to use this as a tool. And I think to the extent that that tool is not on the table for Dominion, then I think that tool needs to be evaluated, and if there's the potential for that to be used for the benefit of, quite honestly, everybody, because if you can reduce costs, then that's going to benefit the ratepayers, of Dominion, and it's going to benefit the QF facilities through a lower VIC charge. So I think that really is a trend, and I think it's something that the Tampa study that we cited. This concept of using solar curtailment as a way to reduce the cost of integrating solar was probably an underappreciated concept maybe 5, definitely 10 years ago. But I think more and more utilities are starting to realize this. And of course, it only matters when you get to higher penetrations of renewables. This is not really a viable option if you just have a little bit of solar on the system. So I think this is something that I think needs to be evaluated, and we just want to make sure that the company's not tying one hand behind its back in terms of integrating higher penetrations of renewables.
Thank you. And what I'm hearing, I think, from you and from Dominion is the good news is that it sounds like all the concerned parties going to be discussing these things, receiving and giving feedback, and that can be a good thing. Do you agree?
I agree. Yes.
I know I need it, and I get it at home quite a lot. Thank you.
Thank you.
Thank you, Commissioner Caston. Any further commissioner questions? Hearing none, Mr. Ming, you may step down. We will now recess until October.
Chair Powers, may I clarify something on the record, please?
Certainly.
In my colloquy with Commissioner Belser, I gave what sounded like inconsistent answers as I reflect on it, and I certainly want to clear that up. On one hand, we have a commitment in writing from the company that SECEBA can participate in a technical review committee concerning the VIC, which is very important to SECEBA. On the other hand, there is no written agreement that we would do that. There's no side agreement, no agreement signed or anything like that. A simple commitment from the company is all we have.
Thank you, Mr. Witt.
Okay, thank you.
I did overlook one thing, no redirect on this witness.
No redirect, Mr. Chair.
Thank you very much.
I was just going to say, Mr. Chairman, that is correct. And I was concerned Mr. Witt was going to take back his Southern gentleman comment. I'm glad that's still on the record.
And we'll remember that. This hearing does not adjourn now, but we do recess until Thursday, October 2nd, 2025 at 10 a.m. And at that time, we'll hear testimony from the third-party consultant that is now working on this matter. Is there anything further from any parties at this time?
Nothing from the company.
All right, Lord willing, we'll all be here on October 2nd, and we'll see you then. We are in recess.